taking away, he is taking it away from the innovator by filing a para 4, and he is challenging the validity of innovator's patent. Now, this act of filing para 4 itself is considered as infringement. Why it is considered infringement? Because when somebody owns a patent on it, nobody can market or sell or manufacture that invention before the expiry of the patent without the approval of the innovator. Now, here, the generic drug manufacturer is asking to market and sell its drug before the expiry of the patent, and the innovator is not agreeable to this. So this itself is an infringement. So as soon as the generic drug company files a para 4, the innovator files the infringement suit, and as soon as the innovator files the infringement suit, there is a 30 months stay, automatic stay on the approval process by the FDA, and the generic may or may not come into the market. So please bear this in mind that for a generic company, it is a big deal to file a para 4. It is a great risk it is taking. Why so? Let us see what happens as soon as a para 4 is filed. So para 4, filing a para 4 is challenging the inventor, challenging the innovator that I am challenging your patent. So generic manufacturer as if is warning the brand name manufacturer or innovator that the existing patent which you hold is invalid and it will not be violated by me. In reply, what does the brand name manufacturer or the innovator does? He can file a patent infringement lawsuit even if the authentic claim by the generic manufacturer. So even if the innovator knows that what the generic manufacturer saying is true and actually his patent is invalid, still he can file a patent infringement suit because he owns a patent. Now, this suit, if the innovator wants to file this infringement suit, he has to file it within 45 days of the para 4 filing. If he doesn't file this infringement suit within 45 days, FDA doesn't do anything and he can start looking into the approval process of the ANDA. But if he files it within 45 days, which he generally does, FDA doesn't give approval to the generic manufacturer for a period of 30 months. I'm sorry that 30 months is not visible, it is below. So for the period of 30 months, that is for 2.5 years, there is an automatic stay. After 2.5 and during this period of 2.5 years, the infringement suit is heard by the courts. Now, at the end of 2.5 years, the court might have decided on the infringement. They might not have decided on the infringement. If they have decided on the infringement, they might have ruled in favor of the innovator or they might have ruled in favor of the generic drug manufacturer. We'll see what happens. But after the 2.5 years, even if the courts have heard or have not heard, so if they have not decided on the infringement suit yet, US FDA may want to grant the approval or they may not want to grant the approval. It depends. It is at their discretion. Now, what happens when the courts decide that the infringement is not there? The court decides that actually what generic manufacturer was saying was true and the patent owned by the innovator is really invalid. So if it is invalid, then it will be invalidated by the court and it will cease to exist. Now, when this happens, the generic manufacturer can immediately enter into the market. And in such situation, it has a 6 months or 180 days marketing exclusivity, which means for the next 180 days, no second generic can enter in the market. So this is a reward given to the generic manufacturer for challenging the patent owned by the innovator. मराठीत सांगायचं झालं तर जेनेरिक मॅन्युफॅक्चररनी ही हिंमत केलेली असते इनोव्हेटरला चॅलेंज करायची, त्याचं पेटंट चॅलेंज करायची. त्याचं बक्षीस म्हणून पेटंट इनव्हॅलिडेट झाल्या त्याचं ANDA अप्रूव्ह करतं FDA आणि असं सांगतं की पुढचे 6 महिने आम्ही दुसऱ्या कुठल्याही जेनेरिक मॅन्युफॅक्चररचं ANDA अप्रूव्ह करणार नाही. पॅरा 2 जेव्हा फाईल होतो किंवा पॅरा 3 फाईल होतो तेव्हा असं नसतं. आणि या जेनेरिक मॅन्युफॅक्चरर बरोबर इतर अनेक जेनेरिक ड्रग मॅन्युफॅक्चरर्स अप्रूव्ह बाजारामध्ये उड्या मारतात. What is the advantage the generic manufacturer gets of this 180 days marketing exclusivity? We know that if a price of an innovator drug before entry of the generics was 100 rupees, as soon as the patent expires and the generics start entering in the market, the prices start reducing, and it so reduces that 100 rupees drug starts selling at 5 rupees because there are so many generics in the market and there is a huge competition. Now, in this situation, when the generic drug manufacturer has filed a para 4 challenge and won in the courts, it gets a 180 days marketing exclusivity. So no other generic can enter. There is no competition. And he can sell that 100 rupees drug at 80 rupees. Mind well, here the generic drug manufacturer has not spent so much on invention as that of the inventor. जेनेरिक ड्रग मॅन्युफॅक्चररनी रिसर्च कमी केलेलं असतं, क्लिनिकल ट्रायल्स केलेल्या नसतात, त्यांचा खर्च कमी झालेला असतो आणि तरी त्यांना 80 रुपयाला ते औषध विकता येतं, जे अदरवाईज पॅरा 2 किंवा 3 चॅलेंज 3 सर्टिफिकेशन फाईल केलं असतं तर त्यांना 5 रुपयाला विकायला लागलं असतं, जे त्यांना 80 रुपयाला विकता येतं. आणि हा जो फायदा मिळतो त्यांना या 6 महिन्यात 5 रुपयाच्या ऐवजी 80 रुपयाला विकण्याचा, तो ह्यूज असतो. दे कॅन ऍक्च्युअली मिंट मनी. Why is this advantage given to them? That is because they dared to challenge the inventor. They dared to invalidate their patent, because of which सगळ्या कॉमन पब्लिकलाच जेनेरिक ड्रग लवकर मिळायला लागणार आहे. And because of which it is a reward given to them. It is also a reward to common public that because the patent has been invalidated, they are going to receive the generic drugs at low cost sooner, before 20 years. After 180 days, all other generics can enter into the market and the marketing exclusivity ends. So you can see here, when there is a para 4 challenge in the United States, according to Hatch-Waxman Act, there is a huge overlap between the patents and regulatory issues. Otherwise, they don't overlap. I hope it was clear. If you have any questions, we can take the questions after I have finished delivering this talk. Another thing which I mentioned, if you remember, here, another objective of the act is to compensate the innovators for the time lost from the patent term because of the delay in regulatory approvals. How does the act compensate this? By introducing patent term extensions. So in such situation, when there is a delay in approval by the US FDA, then the lost patent term, which is around 6 to 8 years, is partly compensated in FDA. Again, in India, there are no patent term extensions, but in US, when it comes to pharmaceuticals, there can be patent term extensions. Now, how is this term calculated? So after the patent is filed, the innovator had started testing, that is clinical trial. So whatever was the testing phase, so suppose it was a 4 years of testing phase, of which there was a lack of due diligence, which means the innovator did not respond to the FDA's requirements. So out of suppose 180 days of testing phase, 6 days was lack of due diligence. So 180 minus this 6 upon 2, those many days plus suppose the FDA took 8 months or 240 days for approval, of which again the innovator was not diligent for 10 days. So 240 days minus 10 days, 230 days upon 2. Okay, so 115 days here and whatever was before. So if it was 80 days here and 115 days here, so 115 plus 80, 205 days ka extension will be received by this patent. Okay. Now, there is a caveat here. So, even if the patent was likely to expire in Jan 2024 because of this patent term extension, the term has been extended by 6 months. So, the total term of patent cannot exceed 14 years, or the total extension cannot be more than 5 years. This is a, so if this, after this calculation, this extension comes out to be 5 years and 10 days, it cannot be 5 years and 10 days. It can be at the most 5 years. So this is how you can see here, whatever Hatch-Waxman Act tells here, whatever these provisions are, they are for the benefit of generic manufacturer and for the common public. And these provisions are for the benefit of innovator. Then there are antitrust issues. What are these antitrust issues? Whenever, so we saw here the para 4 challenge we were talking about. Whenever a generic manufacturer knows that he can invalidate a patent, he knows that the patent has been wrongfully granted and he has the evidence to invalidate the innovator's patent. Rather than filing a para 4 challenge, what he does is he approaches the innovator and says that, see, I know that I can invalidate your patent, and you also know that. The innovator also knows that the patent is invalid. But rather than filing a para 4 challenge, you pay me some amount and I'll keep quiet. मराठीत ज्याला आपण मांडवली म्हणतो तशी हे करतात. Now, what the entire idea behind introducing this para 4 litigations in the US was to allow early entry of the generic, which will be useful for the generic drug manufacturer as well as the common public. But the generic manufacturer doesn't care about common public. He straightway approaches the brand name manufacturer and says, you pay me some $1 million and I'll keep quiet. I will not file a para 4 challenge. So you keep selling your drug in the market for 100 rupees. I don't want to file a para 4 and win and receive a marketing exclusivity for 6 months. Rather than that, you pay me so and so dollars. I'll keep quiet and you keep selling your drug. Now, this is called reverse payments. This type of payments where the innovator pays the generic drug manufacturer are called reverse payments. When such issues started happening in the United States, America, there is one more act which is called Sherman Antitrust Act in the US, and it declares that such conduct of pay reverse payment, which actually is it is declares that every contract, combination or conspiracy in restraint of trade expressly prohibits monopolies. This is a antitrust. This is a antitrust issue, and they have punished the innovators for making such reverse payments to the generic drug manufacturers. Why they are called reverse payments? Because generally the flow of money is from the generic drug manufacturer to the innovator. But in such cases, there is the flow of flow reverses, and therefore it is called reverse payments. And this has been an issue of antitrust in the United States. And the innovator drug molecules, if they are found to do such reverse payments to the generic, they have been punished with punitive damages. These are some examples. There was a settlement between Abbott and Zenith. So Abbott is an innovator, Zenith is a over a drug called terazocine. This was the settlement, 6 million. The innovator will pay the generic for every 3 months till the patent expires. So these were the deals, and total of $70 million were done in, and this was questioned by the antitrust authorities, and the innovators were punished. So this is a typical new drug timeline according to the Hatch-Waxman Act and patent linkages. Um, brand manufacturer activities, when the patent is filed on so this is a brand name drugs timeline, and this is a generic competitions timeline. So if I on year zero the patent is filed, then the investigational new drug application is filed, then the testing, that is clinical trials, begin, and in the 10th, around somewhere around 9th year, the new drug application is filed, and then in the 11th year the NDA is approved. So if you could see here, a total of 11 years of patent life is lost, and generally half of this, that is half of this period in between INDA to NDA filing, and half of this period between NDA filing and NDA approval can be compensated to the innovator in the US, which is called patent term extension. Now, there is one more thing which appears, which exists in the United States, is called marketing exclusivity. We will talk about this later in the later slide. And then the patent expires actually on the 20th year, but because of the patent term extension, it actually expires after 25 years. So this is the original term of the patent, and this is the Hatch-Waxman extension. During this Hatch-Waxman extension, the generic competitor can file an ANDA. It can get tentatively approved, and after the 25th year ends, the generic is marketed, because here they are filing a para 2 or para 3. But if the generic manufacturer files a para 4 somewhere here, then he will get a 6 months exclusivity after this, and then the generics can enter in the 18th year itself. So that is the advantage of this is how the typical drug timeline for a new drug and a generic drug looks like according after the enactment of Hatch-Waxman Act in the United States of America. So I said about exclusivity. So what is this data exclusivity? It is the protection of the clinical trial data required to be submitted to a regulatory agency, and prevention of generic drug manufacturers from relying on this data in their own applications. So we saw here that the ANDA is filed as soon as the during the life of a patent. You can see here the patent is valid till 25th year, but the ANDA is filed here itself when the patent was valid. So when the generic has to file an ANDA, he has to compare his drug with the innovator's drug, and for that he has to rely on the data which is filed by the innovator with the FDA. Okay, so what is a data exclusivity? It says that you cannot use the innovator's data for first 5 years. So a generic drug manufacturer cannot start working on his generic drug at this point. It has to wait for some time, and then only he can use that data which is filed by the innovator with the FDA. And this is called data exclusivity. It is a protection of the clinical trial data required to be submitted to a regulatory agency. So what data are we talking about? We are talking about the clinical trial data, and that cannot be used by the generic drug manufacturer for comparing his drug with the innovator's drug for a certain period of time. This certain period of time is the time of data exclusivity. So this is in United States, there is a 5 years data exclusivity for a new chemical entity, 3 years for the new indication of a pharmaceutical drug, and 12 years for a biological product. In Europe, it is 8 years. In Japan, it is 6 years. So it varies from country to country. Again, in India, we do not have this data exclusivity provision. Before I forget, this particular arrangement of filing para 4 of patent certifications with the FDA at the time of filing a generic drug approval is called patent linkages, which means the approval of the drug is linked to the patents. Again, in India, there are no patent linkages. So when somebody files an application with the Indian Drug Regulatory Authority for marketing a generic drug, the Indian Drug Regulatory Authority does not require to ensure that whether the generic drug manufacturer is infringing on innovator's patent or not. They will simply check the safety and efficacy, and if they comply, they will grant the marketing approval. And if then the innovator feels that his patent is being infringed, he will have to sue the generic drug manufacturer. So there is no patent linkage in drug regulatory approvals in India. They exist in the developing countries. There are no Hatch-Waxman provisions. There are no data exclusivity provisions as well. So these are the areas where generally the patent and regulatory timelines overlap. And I thought this is something which generally people don't talk about, or we are not aware of being in academia. So that's all about my today's presentation. I'll be happy to answer your questions. Thank you.
Yes, any question from the participants?
No questions.
Madam, there is question.
Yeah.
Is she audible, madam?
No. You can type it here, her question.
Hello, ma'am.
Yeah.
Ma'am, during your session, you talk about the patent can be invalid. Okay. Or generic manufacturer can claim that it can be invalid.
Yeah.
Will you please elaborate this with any example how we can claim it is invalid?
Yeah. So, as I said, the criteria for granting a patent is novelty, non-obviousness, and industrial application. So, if there is already a patent existing or a research paper existing on the claim, so for example, um, uh, some molecule patent has been filed by the innovator and which has been granted by the patent office. So obviously, if the patent was granted, it means that it is found novel. Now, how does the patent examiner sitting at the patent office ensure the novelty? He does a search. He has a database of patents and research papers, which through which he goes, and he finds that nobody has synthesized anything similar. So he considers that it is novel, and he grants the patent. Now, if the generic drug manufacturer finds a research article in which the same drug molecule was disclosed 2 years back, which the patent examiner sitting in the patent office has missed. and because of which he has granted the patent. So if the innovator can find out some such reference with which he can either question the novelty or non-obviousness, then he can invalidate the patent. So what the grounds of patentability are the grounds of invalidity. He can claim if the innovator can, if the generic manufacturer can prove that either it was not novel or it was not non-obvious, or he can also prove that the innovator actually has not made that invention, he has wrongfully obtained it, कोणाचं तरी चोरलंय त्यांनी, असे काही प्रूफ त्यांना देता आले तर these are the grounds of invalidation.
Thank you, ma'am.
Yeah.
Any other question from participants?
All right. So can we call it off?
Yes. We are grateful to you, madam, for insightful and engaging presentation on how patents and regulatory issues entangle.
Yeah.
She truly shed a light on some critical topics of the patents and IPR in the pharmaceuticals, like Hatch-Waxman Act with its objectives, Orange Book, the patent term extension and the patent challenges with the Hatchman-Waxman extension and the data exclusivity. The presentation has undoubtedly provided us with a clear understanding of these key issues and the best practices in the IPR, and it will certainly help us in navigating the challenges and opportunities in this area. Thank you so much, madam, once again.
Thank you. Thank you for the invitation.
Madam, please kindly accept our appreciation.
Next method, that is the Ashwagandha, which is used in case
The
of
next section will start at 11:30.
अश्वगंधा सेकंड क्या यूज किया था?
And the feedback link is shared in the chat box. All participants are requested to fill the feedback.
Why? Because it's having an tonic property, it increases the immunity system. इसीलिए उस टाइम पे ये ज्यादा यूज किया. What's the synonym of this ashwagandha? It's a medallion use. Ashwagandha, ashwagandha, otherwise Indian ginseng. It's obtained from dried stalks of the plant.